2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon to the attorneys. Welcome to the Tennessee Court of Appeals. I'm assuming that the time has been reserved for the rebuttal. Is that correct?
Yes, Your Honor.
Okay. We will proceed in this case as if we were in the courtroom. However, you will not need to stand up. You can sit down, remain seated as you present your argument. Will there be two arguments on one side? Or I see there's three attorneys in the court. Will there be two
Beller
arguments? Sir?
Brandon Beller for the appellant. There'll be the appellee. There'll be only one argument on our behalf, Your Honor.
And then for the appellant?
For the appellee.
For the appellant, Ms. Key was the guardian ad litem.
Okay. Okay. Okay, then. Are you prepared? You're ready to present your argument? Then, Mr. Clerk, will you call the case, please?
Your Honor. In re Lucas S.
For the appellant, we'll hear you.
Please the court, Jacqueline Scott for the appellant, Rachel C. Your Honors, we're here today in regards to the termination of parental rights of the mother of Lucas S. At the time of trial, Lucas was 15 years old. He's currently 17 years old. The mother has chosen to appeal the termination of her parental rights on three separate grounds. First, that the court's ruling was insufficient to meet the procedural requirements. Second, that there was insufficient evidence to prove by clear and convincing standard that the grounds for termination exist. And third, that there is insufficient evidence to prove that it is in the best interests of Lucas for the mother's rights to be terminated. Our chief and primary argument is that the court's written order has failed to accurately reflect the order that was stated on the date of trial. Tennessee Code 36-113K requires specific findings of fact and conclusions of law. However, if you compare the trial transcript to the written order that was submitted, they don't match. The discrepancies between the transcript fail to meet those statutory requirements since we're unsure of what the court's reasoning and desire was. The most glaring discrepancy that I will point out is that in the court's verbal ruling at trial, there were three grounds for termination listed. However, this written order has a fourth grounds of termination that was never mentioned at trial or by the trial court. That one ground that I'll discuss is persistence of conditions. If you go back to the petition, that ground was not pled. And if you look at the transcript, counsel for the appellees listed the grounds that he intended to pursue. And at the end, in his summary, he also listed three grounds for termination. Persistence of condition was never included at any time at trial. The appellee in their brief claims that it was tried by consent, but I don't believe there is any evidence to support that argument. In addition, persistence of condition would not be applicable to this case because Lucas was never in foster care and he was not removed from his mother's home. Prior rulings of this court, such as in Ray, Nevada, state that the persistence of conditions grounds only pertain essentially to children in foster care. I believe that in itself would be enough to overturn the grounds of persistence of conditions. Looking at the other grounds that were alleged and actually tried, they looked first at abandonment by failure to visit. I would state that first, the 4-month period that the court is required to look at in stating whether the mother visited was never defined. The petition states two definitions of abandonment, that of an incarcerated parent and that of a parent who has not been incarcerated, which would be the 4 months prior to trial. It's not clear by looking at the evidence what 4-month period the court was looking at. The mother would also assert that there was no proof that her failure to visit was willful. Now, the mother did not testify at trial. She chose to instead enter her deposition testimony as an exhibit. If you look at that deposition testimony, she states that she made efforts to see her son. However, the appellees denied her any opportunity to see him. She also continues in that vein in regards to abandonment by failure to support. There is no evidence presented that her failure to support the child was willful. I do have to concede she never paid child support. However, she was never ordered to pay child support, and there is no evidence that she was ever able to work or able to earn a living, which would enable her to actually send support for that child. The record
is there proof that she worked at all during this period of time?
There were 2 periods of time in which she did work. However, there are several years in which she did not. She did explain it during her deposition. She did not work at various times because she was taking care of her daughter, but she does have full custody of another child.
Scott, whose burden is it to prove that the failure to pay and the failure to visit was not willful? Who has that burden?
Well, at the time the petition was filed, the statute placed the burden on the appellees. So
And this case was filed when?
this was filed November 13th of 2018.
I think that rule became effective in July of 2018. And it switched the burden.
My apologies. I had thought it was July 2019. The rule change.
Go right ahead, though.
Uh,
But let's assume that I'm correct. What testimony did your client put on to show that her failure to visit and the failure to provide support was not willful?
She stated that she was unable to send support because she had another child in her care. She was not receiving child support for that child, who was also undergoing an action in criminal court that was very traumatic to that child. So she was staying home, taking care of that child, unable to work, and not receiving any assistance there. In regards to the failure to visit, she stated that the father and stepmother, who are the appellees, did not want her to visit, did not return phone calls. She had attempted to send at least 2 letters to Lucas, and she doesn't believe he ever received those.
Okay.
The final ground that was found by the trial court was the failure to exhibit an ability and willingness to assume custody. In light of the Supreme Court's recent decision in Re Nevea, I believe I have to concede the first part of that grounds in regards to the ability and willingness to assume custody. I don't believe that I can ethically argue that that was not proven. We would, however, assert that the second prong of that grounds in regards to substantial risk of harm to the child was not met. The majority of the testimony given was in regards to the mother's conduct in 2015 to 2017. There was not very much evidence of what her situation was at the time of filing. The mother was not forced to give testimony about her current situation. On the day of trial, the only information we have is up until her deposition in June of 2019. The appellees did testify about what they believed to be the mother's circumstances. However, they had no firsthand knowledge of that and were only relying upon rumors and what they had heard from others in the community. Mother also asserts that there was insufficient evidence to prove best interests. Now, the court in its oral ruling did refer to certain facts. However, the non-statutory factors were never addressed by the court, at least at trial. If you look at the written order, each of the factors is addressed. However, I cannot match the court's verbal ruling to what was placed in the written order. And for those reasons, we would ask that the trial court's decision be overturned and the mother's parental rights be reinstated.
Thank you. Thank you. Nothing further on your argument then?
No, Your Honor.
Okay. The appellee.
Good afternoon, Your Honors. My name is Brandon Beller. I represent the biological father, Michael S., and the stepmother, Audrey S. And with regard to taking the court maybe back a little different direction, there was a procedural history that's associated with this case. And just taking note of it and going through my notes today, that there was a motion to deem facts admitted that had been filed, and there were actually some facts that were that are part of the record that are absolutely irrefutable. And I would ask your honors to take note of that. That in one of those particular factors is that the appellant and the minor child had no contact with each other since January 1, 2017. This petition was filed on November the 13th, 2018. That is well in excess of the 4 months preceding the filing of this to establish the basis for an abandonment, the requirement of that factor. Further along with that, there's also in that same order that granting that motion to deem facts admitted, there's also a part of that the appellant had not maintained regular visits or contact with a minor child since January 1, 2015. The very fact that the appellant chose not to testify, not to put on any proof, she's never controverted any of the facts in that order. A lot of those statements, part of that order was that the appellant was found to have used illegal substances, rendering it unsafe for the child to be in her care and control. That was dated as of March 15th, 2019. And going on, the appellant had not maintained a relationship with a minor child, had failed to pay any child support consistent with the child support guidelines. Michael S. had testified over the course of the lifetime of his son, who was age 15 at the time of the hearing. The appellant had only paid a couple of $100s, which is striking to me, in the fact that the proof would also bear out that she had the capacity of making at least $9.95, was in good health, was a licensed LPN, and had a maximum capacity, I believe it was a little over $14.95. So she had the capacity in order but yet she paid no child support after having a legal obligation to do so, except for a couple of $100. That is the proof. But I submit is maybe the mile high point of view when you're looking at these cases about what actually did happen. The record is replete with a mother who had been had an addiction to drugs, methamphetamine, and several other pills. I won't go into all the details of that, but she had several different relationships with different men over a course of time. And even at one point, and I believe Judge Bird even pointed it out in her ruling, that her daughters had been other daughters had been subject to sexual abuse. We don't throw out our common sense in these type of cases. It's just completely inappropriate for anyone to think that's the type of environment you would want to submit a child to. I think that what that essentially goes to is basically the ground of the failure to manifest an ability and willingness to assume legal or physical custody, and placing the child in the person's legal or physical custody would be a substantial harm. Her criminal record, her substantial drug abuse, because she admitted that she had not had any treatment for, particularly the red flag that I remember hanging on to was the methamphetamine use, which in your rural counties is a tremendous pariah that we have to contend with on a unfortunately regular basis. She didn't receive treatment for that. And of course, a lot of the other individuals that she had been associated with, the paramours, and had felony convictions. Now, that standing alone, a felony conviction doesn't necessarily carry over. That necessarily means someone's a bad parent. But when you look at the entire gambit of her choices and bad decisions, I think that there's no question that we've established by clear and convincing evidence that at least 3 of the 4 grounds that have been in the order. Now, persistence of conditions, I'm not going to belabor that argument. We'll rely on our brief, but the other grounds, there's no question that we have established the willfulness of the abandonment, the willfulness of the of failure to pay child support, and the other grounds as well. Now,
But
Judge
Mr.
Burke-
Ballard,
yes,
you're not pursuing the persistence of conditions ground, are you?
I think doing that, I think probably I would concede that with
Okay.
Ms. Scott.
Let me ask you, Ms. Scott said that if you look at the trial court's oral ruling and look at the written order, that they're very different. And obviously they are very different. It included a ground that was not pled, not tried, not argued either on opening or closing. Who prepared the order, Mr. Ballard?
I will take responsibility for that. I did that.
Did you or somebody in your office do it?
Somebody in my office did it, but ultimately it falls to me. So
Okay.
I will take responsibility for what happens out of my office.
Yeah. Well, let me ask you, did the trial court make any changes whatsoever in the order that you presented to her to sign?
No, the trial court signed it, and there was no motion to alter or amend judgment. There was appeal as a matter of right taken straight after that within the 30 days. So there was nothing else to that. Judge Birch signed it, and we filed it.
Yeah. Let me ask you, do you handle a number of termination cases?
I handle enough. My wife handles more than I do. I might handle 1 or 2 or 3 a year.
And then you've got some boilerplate stuff that you normally use in terminations.
Yes, sir.
In this case, did you go back through and look at it and take out stuff that
I
wasn't?
did, just not enough, Your Honor.
Okay. Yeah, because there's stuff in about, well, nobody filed a paternity action, but you wouldn't file a paternity action here because they were married and this was a
Correct.
child born during that marriage. It's just a lot of stuff that indicates that somebody wasn't looking at this order. So it raises a question in my mind, is the order an independent judgment of the trial court? Because, trial courts are supposed to exercise their independent judgment.
Yes,
when
sir.
they enter orders.
And that's the reason I pointed out and understand that the order with regard to the motion to deem facts admitted under the request for admissions is part of the court's order, in my opinion, in the record that the court was looking at. Of course, the court also had the benefit of reviewing the entire depositional transcript as well, and made allusion to that in the ruling. So I don't think that the court did not exercise independent judgment, if that's ultimately your question.
Yeah, that was my question.
Okay.
Whether the court exercised her independent judgment in rendering this order, because it appears to me from reading it and looking at the transcript of the proof, which I did, and the argument, it's very different. And you've got to wonder, an experienced trial judge in a termination case would have known, for example, persistence of condition. This is not a case, you've got to plead these things. And in this case, the child was never removed from the mother, so persistence of condition would never come into play. And so when you see that in the order, if you really looked at it and exercised your independent judgment, you would have to strike through that, because it's not relevant to the facts of this case.
Certainly.
But that's why it raises a kind of a red flag in my mind.
I understand, Your Honor, and of course, you know, we try a lot of these on a regular basis, but I certainly wouldn't want the court to overlook the substantive value of what is in the record already. I mean, obviously, we've pointed out several factual bases that would support the legal requirements of the statutory grounds for termination of parental rights.
Do you think there's enough in there in regard to the best interest determination in terms of the statutory factors? Because in the oral ruling, the judge really doesn't say anything at all about even looking at that code section or even talking about what the statutory factors are in connection with best interest.
She cites to the code to the best of my recollection, the actual Tennessee Code annotated.
In the order.
In the order. And I want to think is in actually the transcript of the ruling too.
I didn't see it in the transcript of the ruling. Maybe I missed it though. I could have.
But even with that, Your Honor, when she goes through in her ruling each and every element that is supported, and we've set it out in our brief, it looks like to me it was a summation of the findings that the court had. So it's almost overlapped to a certain extent. And we would argue that we pointed out in several, in our brief, all the factors we felt like that were met as far as what was the best interest was required. And I believe even the appellant, even in their own brief, had conceded that the court's conclusions with regard to not maintaining the visitation of contact with the child would have been an element of the best interest of whether the parent or guardian does maintain regular visits or other contact, whether a meaningful relationship otherwise had been established between the parent or guardian and the child. That goes back to the court actually addressed that in the ruling, that there was no relationship with her son at this time. So there were some findings that indicated that those statutory criteria had been met. Is what I wanted to point to the court on that.
All right.
So, but other than where those, we certainly believe that given the overall totality of the and scope of the trial, the depositional transcript weigh very heavily, and that we had met our burden of proof by clear and convincing evidence, and would certainly request that the court affirm the decision of the trial court. That's what we're asking for. Thank you.
All right.
Okay. Anything further? Then your case has been submitted to the panel, and you will receive our opinion in a due course of time.
I think she has 4 minutes on rebuttal, Your Honor.
Oh, I'm
Yep.
sorry. I'm trying to rush you out of here. Go right ahead.
Well,
Substantive rebuttal. I feel like
let me ask you, Ms. Scott, on before you get started. This child is 17 years old. He said he doesn't want to have any relationship with his mother. And I really kind of don't understand, on a termination file this late. I kind of don't understand why the petition has filed it. And I really kind of don't understand why the mother is contesting it. Because, if we were to, for example, send this case back before it ever reach us again, the child would be 18 and the father could adopt not the father, but the stepmother could adopt the child. And the mother wouldn't have a right to be heard on that. I mean,
yes, and
I really don't understand even pursuing this appeal in some ways.
this is a case in which I advise my client of her options, and I feel I'm obligated to pursue the path that she has chosen, while also having to balance my duty to not make meritless or frivolous arguments before the court. The appellate court has found that in termination proceedings, an attorney cannot withdraw unless they provide notice to that client. With all candor, I have not been able to reach the mother for some months in order to provide her with any notice or to ask her if she even wishes to proceed. I can only follow the instructions she last gave me during our last contact.
And she's had no contact with you since the trial?
since approximately 1 month after the order was entered. She did contact my office stating she wished to pursue the appeal, instructing me to file the appeal. And since then, I've been unable to locate her.
But you were appointed to represent her, is that right?
Yes.
Okay. Go right ahead. I don't have any further questions.
I would have no other argument, Your Honor.
Okay.
Nothing further. Now your case has been submitted to the court for resolution. You will receive our opinion in due course of time. I want to thank the attorneys for your presentation.
Thank you.
The attorneys may be excused.
This honorable court is now adjourned.
Thank you.
Thank you, sir.